I'm very happy to stand in support of this legislation. Thank you.
Honourable Clayton Cosgrove.
Mr Chair, I have some vague recollections of this bill, having served on the Law and Order Committee at the time that it was put through, and like other members, am a wee bit, find it a little bit strange, the attitude of the government that says that after after a great deal of urgent pressure, quite rightly so, given the circumstances, was put about to get this legislation through. And then, as my colleague Leanne Dalzell pointed out, like a number of other bills, it languished on the order paper for a year. And this minister has decided to bring it to the House and push it along, then to be criticised as an opposition because we dare to actually challenge the authority of this minister and perhaps put up cogent questions and raise issues. We dare to sort of... I'm sorry? Indeed, ideas. My colleague says that I'd put up ideas above my station there, absolutely. You know, that would be considered patronising, of course. But what the minister forgets is, of course, this is a parliament and this is a democracy. And unlike in her little world, it may be that people aren't allowed to ask questions, aren't allowed to put hypotheses up, aren't allowed to criticise in her little world that she orbits from time to time. But this isn't, I wasn't being patronising, I was being factual. But in this place, an opposition is charged with the responsibility of challenging a minister. And this minister and this government gave this bill such priority. And we have in the House the sort of, you know, the political cadaver in the front row there, Mr Banks. This government gave this legislation so much priority. Oh, I'm coming to you, don't worry, I'm coming. Hold on, help us on the way. So much priority that I can smell pork, that Mr Banks's bill, sir, you'll recall this I'm sure, had a higher priority, the regulatory reform bill, than this urgent piece of legislation.
Point of order.
Oh, we got him out of
order. Point of order, Honourable John Banks.
Mr Speaker, I don't know the name of the member, but the member speaking is not addressing the part in the bill quite specifically. It's more like a third reading address, and he's just about completed half of his speech. Can I put it to you that you need to haul him into line under standing orders?
Yeah, well, I will ask the member to speak on part two. Clayton Cosgrove.
Very happy to speak on part two, sir, and especially as other members have, and maybe Mr Banks wasn't listening, but you never ruled out other members who talked about the priorities and the delays in getting part two through. So where I left off, I'm glad to see the members alive and kicking. He's out of the crypt, he's ready to roll. And as I said, sir, that this government gave this bill such a priority that Mr Banks's regulatory reform bill, which I won't go into,
Order. The member doesn't need to raise it. I've asked the member to speak to part two.
Which of course, sir, unlike part two, which deals with some substantive issues, I think, what was the clause, expunged 31 acts which don't exist. And I won't go into that bill anymore because we're here to talk about part two. But such was the priority that this government placed on this jury protection measure that another piece of legislation that expunged 31 acts that don't exist was put up ahead of it. Now, Mr Banks may not like it, but that's a fact. The minister, I'm sure, may not like it, but after all her posturing and patronising attitude, questioning us and saying how outrageous it is that we even ask questions and raise issues about such a serious matter, her priority list, led by Mr Banks's legislation, took a bigger priority than this jury protection legislation. Far bigger priority. So she can sort of sit there and smile away as she does, but in this Parliament, Minister, we get to ask the questions, we get to raise the issues, and that Minister, sir, will go down on record as a person who puffs and blows and talks about urgency and talks about priorities. And then, of course, sir, we have the reality of this piece of legislation coming out of the Select Committee, a Select Committee, I've got to say, that was chaired well by Ms Dean, well, I think, from memory. It was efficient, it went through. The problem for Ms Collins is it sat around for a year. It sat around for a year.
A point of order.
A lot longer than the member. I know standing orders. You know standing orders. He's got to address the part in the bill. He's rambled on. He said he wants to ask questions and get verification. He hasn't asked one question or asked for verification. He must address his propositions to the part in the bill being addressed in these committee stages. They're quite a narrow debate, I put it to you, Mr. Chairman.
Relevancy is really the role of the chair to determine. I've listened very carefully to the member, and I have mechanisms available to me. Mr. Cosgrove, part 2.
Indeed, I'm sure you'll exercise your those mechanisms. Absolutely, sir. I have great faith in you. The question I want to ask to satisfy Mr. Banks's penchant for ideas is I want to ask the relevant section on page 11, clause 7. A breach of subsection 4 or 5 may be dealt with as a contempt of court. So in the minister's little world, if you make a breach, you're subject, if you're a murderer, for instance, to a contempt of court. That is the only offence mechanism, I'm advised by learned counsel on our side, that is contained within this part. No big deterrent. She's not going to go out there and crush their cars or dance on them or anything like that. It's simply a contempt of court, which is a penalty of which is at the discretion of a judge.
So the question is that the Minister's amendment set out on SOP 92 be agreed to. Those of that opinion will say aye. Contrary, no. The ayes have it. The question now is that part 2 as amended stand part. Those of that opinion will say aye. Contrary, no. The ayes have it. The question now is that clauses 1 to 3 stand part. Charles Chevelle.
Thank you, Mr.